If you ask Representative Harry Niska or other Minnesota Republicans, the verdict on a now controversial state hiring policy is as clear as day.
In this case, the government being an employer cannot discriminate on the basis of race. That's against federal law very clearly.
The policy's been in place for decades, according to DHS, but made its rounds on social media last week and is now in the spotlight. Niska argues that requiring justification for hiring a non-underrepresented candidate over an underrepresented one is against the law.
Federal law only allows for some sort of potential for affirmative action in circumstances where there is some very clear evidence of past discrimination.
The Trump Department of Justice appears to agree. The DOJ launched an investigation into the hiring practice last week, continuing what many see as a theme of cracking down on affirmative action policy.
They want to get rid of any efforts to give a thumb on the scale or what they perceive of as favoritism to candidates based on race or sex, including efforts to rectify historically disadvantaged groups.
Matthew Bodie is a professor of law at the University of Minnesota. Bodie says the law has remained unchanged for decades through both Republican and DFL administrations in the state. But efforts from the U.S. Supreme Court indicate that the federal stance on affirmative action is changing.
Any effort to take membership of one of those protected classes into account is problematic from the Chief Justice perspective and from the rest of this Supreme Court.
Bodie sees it as a sort of shift away from the original intent of affirmative action to try and offset what many believe are systemic disadvantages. Niska supports that shift.
Certainly, the Trump administration now is making sure that that their Justice Department and their enforcement agencies are aligning with that.
Reporting in St. Paul, I'm Quinn Gorham.